Council regular meeting of November 18th. We are heading into these darker days of winter, but hopefully a little more snow will come along our way as well. I'm going to call the meeting to order and ask Nicole, will you call the roll?
Councillor Benedetti.
Here.
Councillor Doyle.
Here.
Councillor Guth.
Here.
Councillor Rose.
Here.
Mayor Richards.
Here. We have no scheduled public appearances today. We will go right into citizen comments and petitions. This is a time for any citizen to address council on issues not scheduled for a public hearing, and please limit your comments to about 3 minutes. Tony, first up, let's go.
Thank you so much.
Thank you.
That means I get to go home early tonight.
Perhaps.
I hope so. For the record, my name is Tony Kronberg, and happy fall to everyone. And the comments that I'd like to make right now should really probably be when you're talking about the budget tonight, but this is not a line item in the budget. So I think it's probably more appropriate for me to speak about it now, because I don't think you're going to do anything about it in the budget. And of course, it has to do with the outside swimming pool at the recreation center. And I know the last time when you're taking a look at the master plan for the facilities for the Aspen Recreation Center, that some of the comments were that you thought that voters or people had construction fatigue, and that was one of the reasons why you didn't want to move it forward, and that also that the staff would be stretched. Well, it's my understanding that it's a different staff than the lumberyard and the armory housing, that is the Parks and Recreation staff. And then so far as construction fatigue, that is definitely coming down the road, and that this might be a great community benefit for people to actually go to the recreation center, be able to swim outside, bring their kids to the hot tubs. And one comment that I wanted to make was that this is really not a construction project. It's not like building a building, and all it is digging a hole in the ground and pouring some concrete. So it's really a different animal than a construction project. So I just wanted to keep that on your radar screen, because it's been on my radar screen for 50 years, and we've had 4 votes on it. We've gotten funding for it. Every year we keep getting promised for it. And with the state of the nation right now, and with mental health concerns with many people, I think that this would be a wonderful addition. So again, I know you're not going to talk about it tonight, but I just like for you to keep it on your radar screen.
Thank you, Tony.
I'm going to hire you to build a pool for me if you can make it.
I'm sorry, what was that?
It's that easy. I'm hiring you to build a pool for me.
Yeah.
I'll take it. I'll take it.
I feel I need to clarify a few of your recounting of the statements that were made at the center discussion on the ARC, and it was more a larger master plan and all the things that are contemplated and considered for potentials up there that would result in a little more construction fatigue when you're talking about the potentials of a second ice or a gymnasium or a field house or all the things that were discussed in that work session. The idea of an outdoor pool was not really discussed, although I have always been in favor of that. And when the original ARC was built, that's why it was piped for an outdoor pool. And if you recall, Tony, you were opposed to the funding measures that we passed for the ARC because it didn't have a high dive and a deep water well for a high dive. So it was for other councils. I actually got the money for an outdoor pool when we did the debrucing of local property tax, but it was a different council. I believe perhaps under Mayor Ireland, and Tory was there, and others who could not settle on a pool design without blowing it up to close to $3 million, $4 million, because they talked about a wave pool and outdoor sliding and everything like that. And so they eventually canceled it altogether and sent the tax money back. So there is no funding sitting there waiting for a pool outdoors. That was a single measure, and they did not take advantage of it. But we all know it would be nice to have an outdoor pool in the long line of repairs and upgrades that need to happen to the ARC facility itself right now first. So it's not on a priority list. But thank you for continuing to push for it, because it would be a nice amenity and eventually the community can afford it. But we do not want to get spread too thin right now. Thank you very much, Tony.
Thank you so much for your support of it, and I look forward to you leading the charge.
Eventually.
Thank you.
Thank you. Are there other members here for public comment today? And we look like we may have one public comment on the phone with BJ's iPhone, or B's iPhone. Who is this? Are you raising your hand to speak? B. Okay, you are now allowed to speak. Can you tell us what your public comment is, please?
Yeah, I'm just speaking about your proposed to remove the annual short-term rental affidavit.
Okay, can you identify yourself for the record, sir?
Yes, ma'am. I'm Brian Wendell, W-I-N-D-L-E.
Okay, thank you. And that is a public hearing, and so our public comment at the beginning of the meeting is for items not on the agenda. If you will tune back in or follow the meeting until we get to short-term rental public comment, I can accept your comment then.
I will do that. Thank you.
Thank you very much. I appreciate that. Is there one last call for public comment? There being no one for items not on the agenda, we will close the public comment section of the agenda and move on to council member comments. So who would like to go? John?
I just read in the paper today that Mammoth Lakes, California had a forest fire and they put it out, and while they were returning to the base, another one was reported and it blew up so quickly that 3 different communities south of Mammoth Lakes had to be evacuated. They did put it out. They're watching it to make sure it doesn't reignite, but I would point out that it's November 18th, and this is really unusual to have forest fires starting this late in the season.
Thank you, John. Appreciate that. Christine?
No comments tonight.
Anybody else? No? No comments? I do have some reports, but I didn't get a printout of those, so it's going to take me a second. I think the number one issue is no overnight parking. We're wanting to remind people that there is no overnight parking in Aspen. This becomes especially important with snow removal, which we're all counting on coming down the pike pretty soon here. Beyond that, it is fair to say that the final call for the artists who might want to be participating in the city's community art enhancement programs is coming to an end. So please apply if you've not yet already done that. So thank you very much on that. Let me see if it's here. Ooh. Nope, nothing else. Those were the only 2 announcements this evening. Thank you very much. And then in terms of mayor's comments, I did have one thing outside of the comms report. I wanted a couple of things to bring up. One is to wish everyone a happy Thanksgiving. We're not going to have a meeting again until December 2nd, and so I hope it's a time of peace and joy and family reunions. And for those who have to work, I hope it's a day of big tips and appreciated double time or something like that. So that's it for Thanksgiving. The other is to bring up that we as a council received a request for sponsorship of an event called the Ruby Rescue Run, which raises funds to assist the Aspen Animal Shelter with animal rescues, whether it's abusive situations or puppy mills or other animals that they can take in and clean up and soften their edges and then rehome them. And so it is sponsored by Megan Ruby, and she's asked, can the council or would the city be interested in sponsoring? The challenge we're facing is that it is a fundraiser for an existing nonprofit, and we do not do those through the grant committee. So the nonprofit of the animal shelter can apply for a grant, and they do for their ongoing operations. But for a special event that is raising money for something else, it's not appropriate to do pass-through. I think I explained that correctly. And so the alternatives are for council to consider, would we like to fund this event in the fall of next year of 2026 with a sponsorship? And the appropriate avenue for us to do that, should the council wish to, would be through our contingency fund. And speaking with our manager, I believe we have roughly a little under $30,000 in the contingency fund. There have been no real contingency expenditures out of it by this council, and just one prior in the last council. And so looking through, and I think others have seen this, the email that circulated with the sponsorship list starting at $500, $750. I think the $1,000 sponsorship was called a rescuer, and going up and from there, we go into higher numbers. I would like to propose that the council consider $1,000 from the contingency fund to sponsor the animal rescue. And I'm doing this for a couple of reasons. I participated in last year, and I saw a lot of people this fall having a lot of fun up at Buttermilk, even in the rain, kids in backpacks and babies and dogs, and it just seemed like a great community gathering for a good reason. And I think of us as being a real dog town, and on my lunch breaks or whatever, I go out and watch people playing catch in the Rio Grande field and all the dogs running around, and it is a dog town, and this is to help save puppies. I don't know what store you can go into without getting a dog biscuit somewhere, so that seems appropriate to me. And then finally, it's something that brings the community together without having a $200 ticket and a $500 ticket. And there's so few community events, it seems, anymore that aren't a fundraiser that doesn't cost you an arm and a leg. And so I wanted to try to continue this one. It's going to be really exciting that it's going to be in town, starting over near Co Park, not the same uphill that Buttermilk might have intimidated a few short-legged dogs. And so I'm just putting that out there for the council to get your input and see if you agree to that amount, or if there's another different amount on the sponsorship list you are interested in. John?
Yeah, you had me at puppies. I fully support this, and I could even go a little higher than $1,000.
Okay, thank you for that.
Yep.
Sam or Christine or Bill? Sam?
Yeah, I'm happy to support this, and I just always want it not to open the floodgates of getting a million requests, but this one I definitely can support.
I appreciate that, and quite honestly, there's a reason why there's a contingency fund for things that don't quite fit in square pegs and all the round holes we have. Bill or Christine?
Yeah, I echo exactly what Sam said and was going to say the same thing. It's supportive of this. This is not a short circuit or a shortcut, I'm sorry, for our grants program, which a ton of work and thought has gone into, and a lot of community volunteer time goes into sort of reviewing how those funds should be distributed. But given that this doesn't fit and seems to be a good community event, I'm supportive of it.
Thank you, thank you. Christine?
Same, and I ran it. I'm happy to support it. It was a great event.
Did your dogs like it?
He had a good time.
Do we need a formal motion on that, Pete?
No.
Okay, thank you. And thank you all for your consideration of that topic. If we do need a formal vote, let me know later. We'll do it at the end of the meeting.
I think you can give direction to your city manager here because that's within his authority once he has your direction. So,
Okay.
thank you.
Thank you very much. We will now move on to city manager comments.
None for today, thank you.
Thank you. And we'll go on to board reports for anything that happened since our last meeting, which was only a week ago because of the weird schedule in November and December.
I'm happy to start.
Yeah, Pete, go ahead.
Rachel and I had the RAFTA board meeting last Thursday, and for me, the most interesting takeaway and that I wanted to share with everyone was about initial data from the Fair Free program. And preliminary data from October has come in. They said wasn't final quite yet, but it was showing 4% year-over-year increase, just under 4% year-over-year increase from October this year versus October last year. One caveat to that is that September year-over-year was actually down. So they didn't give us specific reasons why September was down versus last year, but they suspect that without Fair Free program, October may also have been down, so it may be greater than just under a 4% delta. So not anything conclusive yet, but some indication that it's working.
Just to elaborate on that, I sent our most recent financial report for October to RAFTA as well, because if we were seeing, as we were, a little bit of decline in business, that might mean a decline in employment and therefore demand at all. So RAFTA did say they also were waiting to hear from their standby buses, the backup buses, when the buses get full, for a full report on that. They didn't have that yet, and felt they'd have more of a full report in January. But it is interesting to look at. The other good news was hearing that Garfield County is putting in $250,000 towards the $900,000+ hogback route. But they're not funding it at the levels they have in the past, and they said that this would be the last year they would fund that route. RAFTA has increased the daytime routes, which make that route much more usable for people, but it is really only funded through the end of the spring season. It is not funded for a full year because the funding is not there from Rifle and Silt. They're contributing a little, I believe, from their general funds, but there's bigger questions about the transit that they would like to have in the future or not, and concerns that the classic Aspen love-hate affair is blooming with, it's really an Upper Valley problem. You guys should pay for the whole thing, as opposed to any real appreciation of the paychecks that come home on Friday night. So I'm not sure where that's going to go in the long term. Other board reports? John?
Yeah, I attended a Rudai Water and Power Authority meeting, which was the first one since last May. Anyway, let's see, April Long, who's now working for Western Mountain Regional Housing Coalition, is giving up her position at WAPA, so we are interviewing some new executive director candidates on December 5th and December 10th. We talked about the aquatic nuisance species program, which hasn't been affected by federal budget cuts, but zebra mussels have been found from the Colorado border as far up as Eagle County. And so we've officially been declared invaded. New Zealand snails have also been detected, and these are both not good for us. Let's see. Our budget is healthy. We're back on track. We also talked about the Shoshone Power Plant water rights. It's in court right now, the Front Range versus the Western Slope. And there's a decision due next week, and the Western Slope needs to raise the money to buy the water rights, and we have 1 year. Also, aquatic nuisance species statistics, inspections were down, decontaminations were down. There were 4 full decontaminations last year, and there were 0 this year. So we're doing our job up at Rudai and doing it well. It's some other parts of our regional water system that aren't in as good shape.
Very good. Just to add on, in case anyone isn't aware of why we're concerned about zebra mussels, they are not edible, but in particularly, they cluster onto all the inlets and outlets and pipelines of water delivery systems. And places that have them in spades spend millions and millions of dollars annually with divers and tanks going down to clear the pipelines and keep the water flowing. And so for a long time, it was believed they really couldn't populate colder, high-altitude areas, but we're finding them throughout Colorado now, and they get, the larvae get transported from lake to lake in the bilge water of a boat. And so this is why we do inspections, and this is why we're trying to avoid the cost of keeping our Rudai water and power electric facilities.
I would add that they've been found to not just travel in boats, but also in stand-up paddleboards and hip waders. So it's important to rinse all your watercraft. Anything you put in the water, rinse it off when you get out.
Okay, thank you. I think that basically concludes our board reports, unless Christine or, nope, okay. Great, thank you. We will move on to the consent calendar. And those items today are resolution number 143, series of 2025, the City of Aspen Financial Policies Update, and resolution number 157, series of 2025, the Aspen Chamber Resort Association Contract Addendum. Is there a motion to approve the consent calendar?
So moved.
I'll second.
Okay, Bill has that. John is the second. Would you call the roll, please, Nicole?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes, thank you. We have no notice of call-up items to discuss this evening. We will go on to the first reading of ordinances. The first ordinance is ordinance number 14, series of 2025, City of Aspen unclaimed property. And if we'll have a staff member go over this briefly of why this is on our agenda tonight and what is it all about, we will greatly appreciate that.
Thank you, Mayor and Council. Matt Grau, Budget Manager for Finance Department of the City of Aspen. And Ordinance 14, Series 2025, is a request on first reading to approve proposed updates to our municipal code, Title II, Sections 2.08.010 through 2.08.030. And these proposed changes will align the City of Aspen policy on unclaimed property with the state of Colorado, essentially aligning us with the Colorado Revised Uniform Unclaimed Property Act. So shifting from our own internal policy to follow state's policy.
Now, where would someone go to look and see if we had any other unclaimed property?
Good question.
State Treasurer's Office website has an unclaimed property option for people to go in and search for their name to see if there's any unclaimed property that they can claim.
Okay, can we put that information in our next community newsletter?
Sure.
Okay, thank you. Is there a motion to read ordinance number 14?
So moved.
Second?
Second.
All in favor of reading the ordinance?
I think roll call.
Yeah, that's what I meant. You give us a roll.
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes.
Ordinance number 14, series of 2025, an ordinance of the City Council of the City of Aspen, Colorado, adopting code amendments to the Administrative Code, Title II, Chapter 2.08, Disposition of Unclaimed Property.
Thank you for that. Is there a motion to pass this on first reading to go to a second reading?
So moved.
Okay. Moved by Sam, seconded Christine. Will you call the roll, please?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you very much. We'll move on to ordinance number 15, series of 2025, 611 East Durant Avenue, the Little Nell Base Area, minor plan development amendment, 8040 Greenline review, and conditional use review.
Good evening, City Council, Mayor Richards, Jeffrey Barnhill, City Planner, City of Aspen. Just wanted to, this is Ordinance 15, Series of 2025, and this is the first reading. This is for the Nell Bell Lift Replacement Project. So this project encompasses 4 properties in the City of Aspen city limits. And this project involves the removal of the Little Nell lift and the Bell Mountain lift, and there will be a single lift from Nell to Bell Mountain. As you can see, a little bit about this is the applicant proposes demolishing the Little Nell and Bell Mountain lifts and replacing it with the new Nell Bell lift. The applicant proposes that these changes will decrease lift ride times, improve skier circulation on mountain, and replace and upgrade aging infrastructure on Aspen Mountain. And the extent of the work in city limits will be the removal of the existing Little Nell lift terminal at the base and lift towers, and the replacement Nell Bell lift terminal and approximately 6 lift towers. So this graphic kind of shows the yellow line is the City of Aspen city limits. So everything to the left of that in this picture are the towers that will be in city limits. And then here's a graphic of the proposed design. Staff recommends that council approve the ordinance on first reading and set a public hearing to review the application on December 2nd, 2025. There's a proposed motion, and I can take any questions that you guys may have for any clarifications for second reading.
Thank you for that. And let me ask if there's questions first for second reading. If anything comes up afterwards, we can ask that as well.
Perfect.
John?
Yeah, I'm just asking for the general public's knowledge because I'm pretty sure I know the answer. The alignment, the top of the lift will be at the top of Bell. Is that correct?
Correct.
Okay. I think it's important people know that.
Yeah.
My only question would be what happens in the area where the current lift terminal is at the bottom on the Nell chair?
Okay.
Any other questions? Yeah, I was a little disappointed when I read that it doesn't have a way station to get off at Little Nell. I'm a little concerned you're going to get skiers far beyond their ability, getting a lot further up the mountain and having to come down, and thinking that they can handle it. And they used to find out on Little Nell they might not be able to handle the rest of the mountain. But that is neither here nor there. Is there again, with no more questions, or John, go ahead.
I did have one comment. I am very excited that the ski company is, in my eyes, taking this step forward because of the removal of the Lift 1A lift in the near future.
Yeah.
So that, I think, answers a lot of the community's questions about two ways to access the mountain. So thanks.
Very good. Is there a motion to read ordinance number 15?
So moved.
Second.
Okay, it's been moved and seconded.
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes.
Ordinance number 15, series of 2025, an ordinance of the Aspen City Council approving a minor plan development amendment to a project review approval 8040 Greenline review and conditional use review for removal of the Little Nell lift and replacement with a Nell Bell lift at the property commonly known as 611 East Durant Avenue, legally described as lots 1, 2, and 3, Little Nell subdivision, common area, residences at the Little Nell, and the portion of parcel 2735-134-00-028 that lies within city limits. It says see Exhibit A for full legal description.
Okay. Thank you for that. Is there a motion to approve on first reading and set for second reading?
So moved.
Seconded.
Okay, it has been moved and seconded, and there's no further questions or comments. I would make a comment that I used to ride the old Bell Mountain lift up to work at Sundeck in the winter season of 1979, and it was a long, sometimes cold, 45-minute ride up to work. So I'm sure people appreciate the new equipment. So if we'll call the roll, please.
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you very much
Thanks so much.
for that item. We will now move on to ordinance number 16, series of 2025, amending Title 23 to update the city sales tax rate to reflect voter approval of an additional 0.30% sales tax for purposes of supporting public education and extending the existing sales tax dedicated to the support of public education. Is there a motion to read?
So moved.
Okay, it's been moved and seconded. Nicole, will you call the roll, please?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes.
Ordinance number 16, series of 2025, an ordinance of the City of Aspen, Colorado, amending Chapter 23 of the City of Aspen Municipal Code to update the sales tax rate for support to the Aspen School District Number 1 as a result of the November 4th, 2025 election results.
Thank you very much. Are there any questions or comments on this matter? There being none, is there a motion to approve ordinance 16, series of 2025 on first reading and move to second reading?
So moved.
Second.
It's Been moved and seconded. Wouldn't you call the roll, Nicole?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you. That concludes the first reading of ordinances section of our agenda. We will now move on to public hearings. And the first public hearing is ordinance number 8, series of 2025, short-term rental regulation updates.
All right. Good afternoon, Mayor and Council. I'm Emmy Oliver, Lodging and Commercial Corp Program Manager. With me here at the table is Louisa Byrne, Assistant City Attorney, Haley Hart, Long Range Planner, and Ben Anderson, Community Development Director. Thanks for having us tonight. We are here to request council approval for the second reading of Ordinance 8, series of 2025. First, before we start, I want to acknowledge that we do have a full agenda for this council meeting, so I am going to attempt to keep this presentation as brief as possible. We'll start with a review of Ordinance 8, and then we'll move on to recap the first reading. And finally, we'll review new information about transferability for estate planning.
And don't feel you need to hurry. This is an important matter.
Okay, thank you. So, as you all know, Ordinance 8 proposes amendments to the definitions and short-term rental regulations sections of the Land Use Code. The amendments are proposed to streamline application process to enhance customer experience, account for scenarios not included in the initial update of the STR code, and increase compliance with existing requirements for STR advertisements. We were last in front of council in September for the first reading of the ordinance. Since then, we've engaged with our stakeholders, including the STR Technical Advisory Committee, STR customers, Aspen Board of Realtors, and community development customers about these updates. I want to acknowledge also that tonight's meeting was originally scheduled for November 11th, and it was continued to today to allow more time for staff to respond to council's requests from first reading. As a reminder, if the ordinance is approved tonight, this timeline would allow for the changes to become effective during the STR permit renewal period, which just began this Monday. And once approved, staff would return in 2026 with a resolution to amend the STR program guidelines, which is the document that accompanies the STR regulations, to accommodate the changes that would be made by this ordinance.
Would they be in effect prior to then or after, not until after that resolution was approved?
The changes in the ordinance would be effective during the renewal period.
That's really just the guideline document.
Yes, the guidelines are like the plain language accompaniment to our code.
That's what I thought. Thank you.
Yeah, sure. All right, we're moving to a review of Ordinance 8 now. So the ordinance was approved by council at first reading, and all 6 topics and bullet points are included in the ordinance, and we'll go through each of those topics individually now. So there are 2 exemptions proposed in Ordinance 8 that would allow STR permits to be transferred. The first is a divorce. If a permittee is going through a divorce and the courts necessitate that the ownership of the property changes, a divorce decree would be required to determine the new permittee. If a permittee passes away, a will or a decree of distribution would determine the new permittee in the second exemption. We will discuss in detail a third option for transferability at the end of this presentation, as it is not currently included in Ordinance 8. The creation of a temporary STR permit type would allow new property owners to fulfill short-term rental contracts that were created by the previous owner. The temporary permit would only be valid for 90 days, and it would cover reservations that were confirmed before the sale of the property. After 90 days, the permit would automatically expire, and the property owners would need to apply for one of the other types of STR permits if they wanted to continue doing short-term rentals at the property. Ordinance 8 proposes removing the requirement to mail public notices for properties in uncapped zones. A posted notice, which you can see an example of in this photo, would still be required as a part of any STR permit application, regardless of the property's location. The posted notice includes the permittee name, the STR address, and the permit type.
And you just didn't say that last bullet point out loud, but public notice is only required for the new applications. So if it's someone renewing, they do not need to post again.
Correct. Public notice is only required upon submission of a new application for a new permit.
Okay, thank you.
Modifications to the HOA requirement would clarify that the HOA affidavit is only required for new applications, and that the affidavit is not required on an annual basis each time the permit is renewed. In place of the affidavit, an applicant acknowledgement is included in the renewal applications that we will show on the next slide. We'd like to acknowledge that there were around 5 public comments, more or less, at last count, submitted on this topic between first and second reading. The majority of the comments were requesting to keep the HOA affidavit in place for renewal applications. Staff acknowledges the public comments, and in response, staff discussed the HOA topic with the city's legal team. Legal advised staff that the city is unable to enforce HOA covenants. Staff's response in the next slide puts the onus on the permittee to acknowledge their individual HOA covenants while still responding to council's direction to streamline the permit renewal process.
Yeah.
So on the left is the HOA affidavit that is required anytime a person submits an application for a new permit. On the right is the streamlined renewal application that would require the applicant to acknowledge their HOA permissions. And it also, sorry, that's being covered up.
Yeah. There you go.
Oh, Adobe, sorry. The renewal application portion on the right would also require that the applicant notifies the city if their HOA permissions have changed since the last time they renewed the permit.
I'm just going to add a comment here. I think we all have seen those letters regarding the HOA, and want to make clear that the city really cannot, again, police and enforce HOA rules, that in many ways it's up to the owners of units to attend their board meetings and be aware of what their HOA allows or doesn't allow. And should the city issue a permit to someone in an HOA who apply for it and said, yeah, I'm allowed to, but then the neighbors complain, wait a second, we don't allow STRs, our HOA does not, that person would have committed fraud, and it would have been a fraud against the city, and that permit would be immediately invalidated. Is that correct?
So, because there's a legal, possibly, yes. So it's once again, it's a lovely legal answer of maybe. So because an HOA, so if there's a dispute with an HOA and the HOA owner, the HOA says they don't have permission, the person says, yes, I do, legally, it would be bad for us to get involved in that. So they could go to district court, and if they came to us with an injunction, a court order saying, yeah, this person, the HOA prevailed, then we would immediately revoke the permit. But because, unless it's extremely clear, we don't want to get into fact-finding in an HOA conflict.
Right. And so what might be the cost of a neighbor to take their HOA to court? Or to say, hey, I have the bylaws here, it says no HOAs, no STRs in our HOA. I have to take it to court to stop this person from renting their use in short term.
I can't really estimate what the cost would be, but, we get into very dangerous territory legally for the city to begin enforcing HOA bylaws and covenants. And so that's why, obviously, we don't want to engage in a fact-finding mission because we're not a court of law. We're attorneys that represent the city.
Right.
And so the best recourse is for them, they have the option of civil action. And that's sort of where we're at, because we don't want to wind up in that situation, because those HOA bylaws, they're not approved by the city. We don't have any oversight over them. And so if we're suddenly becoming the HOA police, I think that's not a particularly great spot to be legally.
I can understand that, and I also understand that we really can't expect the Community Development Office to call and confirm 100 different HOAs every year. Are you still allowing STRs? And I guess I'm just wondering if we should have something perhaps a little more foreboding on the new application and the renewal that says, should your HOA not allow STRs, if any false or misleading information has been given in this item, it shall be, the permit may be subject to immediate invalidation. I mean, I just think making people a little more fully aware that there may be consequences to this. I can't imagine if they've taken deposits and booked people and people have planned a vacation, bought airline tickets, and then find out that that STR is in violation. The neighbors have taken it to court and their permit's going to be removed. So again, I'm just thinking this is, forewarned is forearmed, and the more serious we're able to make our statements on the application and the renewal application, that would be considered fraud and would be grounds to revoke the permit. And
We did add some language to the code that says if you lie on your application, if you submit fraudulent information, you will be subject to penalties.
Yeah.
So that is,
I know it's in the code. I'm saying let's have it on the application form. Let's not say, oh, you didn't read the 5,000-page city code to find that. Bill, comment.
Thanks. I agree with Rachel on that. And I wanted to respond to one thing that I read in one of the
Memos.
written comments from a community member on this, which I'm paraphrasing, but they said the only way for an HOA to monitor ongoing STR permits in their property is with these annual consent forms, if you will. And I would counter that that's not necessarily true, because we publish a list of all STR permits. It's totally publicly available information. So I would encourage those HOAs to get in touch with ME to find how they access that list easily, which I imagine is published online somewhere or available through the GIS or both, and use that as the resource to monitor, which should not be that difficult.
We have the GIS map available that shows all active permits at any time. That's publicly accessible via our website. Lots of customers use it, which is really great to hear. Our staff are also available anytime to provide a list, should someone request like an Excel format of permitted properties, in addition to any other publicly available information they would need to help their compliance efforts within their HOA.
Thanks, Emmy.
Great. Thank you so much. Really appreciate that. I didn't mean to interrupt the flow of your presentation, but I knew we'd be coming back to that topic. So if anyone else has any questions or comments on that,
Mayor, I just want to make a comment that
please.
your suggestion to put it on the application form is very easy for staff to follow, and it does not require any amendment to this particular ordinance for us
That's
to
what
be
I was
able to do
thinking,
that.
because it's just proposed and it's not part of the ordinance.
That was going to be my comment as well.
Okay, great. Well, we're moving forward
Happy to do
then.
that.
Please continue.
Sure. Two exemptions to the STR tax filing requirement are being proposed as well. The first is for a building permit exemption, which would allow a permittee to apply for an exemption to showing STR income for one renewal period. The second exemption is for an act of nature, where if an emergency such as a fire, flood, or unforeseen natural event befell the property, the owner could apply for that act of nature exemption to cover as many renewal periods as it took to repair the damage that their property sustained. Owners that receive exemptions would still be responsible for monthly filings of $0, so we'd still want them to remain active that way in our system. And also to support this, the definition of act of nature would be added to our definitions section.
Thank you.
And then last but not least, the addition of requirements for services that advertise STR properties would make it mandatory that STR permit numbers are included in all advertisements. They also propose that staff could request removal of an ad if it is found to be out of compliance with our existing requirements for advertisements. A definition of short-term rental service would be added to the definitions section also to support this amendment. And so in summary, these are the 6 topics that are included in Ordinance 8 that Council approved at first reading. All the topics we just reviewed were recommended for Council approval by both the Historic Preservation Commission and the Planning and Zoning Commission. And now we'd like to switch gears a little bit. At first reading of Ordinance 8, Council expressed unanimous support for the ordinance, and Council also requested more information about transferability for estate planning at second reading. So in response, staff provided some optional code language around this topic, which you have as Exhibit E in your packets tonight. And on the next few slides, we'll review some background on non-transferability, as well as that optional code language within Exhibit E. The non-transferability code, language in the STR regulations is foundational to the functioning of the program. Our code dictates that there are limited numbers of permits available in 14 zone districts, and we refer to those limits as caps. When the permit limit is reached in one of those zone districts, applicants are placed on waiting lists for the next available permit. In zones with wait lists, the only way permits become available is through attrition. Attrition happens primarily because our code prohibits the transfer of STR permits. On this slide, we've highlighted the existing code language that was used to craft the options for transferability language in the proposed ordinance. So this is the non-transferability clause in our current regulations. The first two exemptions you see on the screen, number 1 and 2, are already included in Ordinance 8. If a majority of council tonight wants to add a third exemption for transferability to encompass estate planning scenarios, staff and legal have proposed 2 options for code language that responds to that. Those 2 options, again, are Exhibit E in your packet. Moving to option 1, this is an Exhibit E. It involves the transfer of a property. So with this option, the permittee could transfer the property to a person or an entity, such as a trust, without the risk of losing their STR permit. The language proposes that the transfer would need to occur as a gift. It could not be as a sale to another person, and it would need to be accompanied by an approved real estate transfer tax exemption. This option would require that the permittee remains the same, but it gives flexibility for estate planning as the property transfer is allowed without losing the permit. Option 2 focuses on the transfer of the actual STR permit to someone in the permittee's family. The person who could receive the permit would be either a spouse or a lineal descendant, as long as that family member has 10% ownership interest in the property. With this option, we also propose adding a definition of lineal descendant, which states that it is any individual, biological and adopted, in a direct line of descent, such as a child, grandchild, or great-grandchild. So again, this option allows for the direct transfer of the STR permit. And due to the complexities of familial relationships, an affidavit from the participants in the transfer would attest to the fact that they are either a spouse or a lineal descendant. So in summary, here are the 2 options proposed for expanding transferability exemptions for estate planning. Option 1 allows the transfer of a property as a gift, and option 2 allows the transfer of the STR permit. Council could choose to insert one, both, or neither into Ordinance 8.
Let's see, let's go through with the staff recommendations first and then come back to this, okay? Bill?
Sure.
Okay,
Yeah? Okay.
thank you.
So it's important to note here that including the third option to the transferability exemptions has the potential to slow permit attrition. It comes back to the idea that we have wait lists for permits in cap zones. In August, we had a work session about changing caps in the RMF zone district, and council's decision was to keep the caps as is because council recognized that the wait list and attrition process is functioning as intended. As an exciting update to that, we've recently, just this week, offered 3 permits to applicants that were on the RMF waiting list, which attests to the success of attrition via non-transferability. For these reasons, staff recommends that council adopts Ordinance 8 series of 2025 without the third option for transferability at second reading. Should council desire to adopt either option presented to expand transferability for estate planning, staff would recommend option 1. And should council desire to adopt option 2, staff recommends adopting the lineal descendant definition to limit those transfers to within families.
Okay, thank you very much.
Yes, of course.
I think we'll hear some council questions first and then go to public comment.
That'd be great. Can we jump back to that slide that has the 2 options on it, please, Emmy? And
This one?
before, yes, thank you. Before I get into my questions, thank you for responding to my questioning here and suggestions. I appreciate it. I know it's tricky to preserve the integrity of the program and ensure there's attrition, but also come up with something that's fair when there really isn't a sale, and that's what I'm hoping to accomplish here, and adapt to people's changing life circumstances, right?
Sure.
Again, in a non-sale situation. One thing that jumped out to me on this slide is you wrote under option 1, that's the more restrictive option, and option 2 is the less restrictive option. Could you talk a little bit about why you classified them that way, please.
Sure. Yeah, we see option 1 as being more restrictive than option 2 because it allows the transfer of the property into a different entity or to another person, but the permittee has to remain the same. Option 2 is less restrictive because it essentially allows that permittee to change over and over. So with option 1, the permit would remain with the same person
Okay.
while still allowing them to make that gift transaction. Does that make sense?
I think so. In option 2, you talk about it allows it to be transferred to somebody with 10% ownership. Is that 10% ownership prior to the transfer or after the transfer?
That would be after the transfer, because that is a current requirement for being a permittee.
So I think you mean before the transfer.
Before the transfer.
Before the transfer.
Sorry, maybe I didn't understand that question.
Yeah, okay, let's just talk it through to make sure we're all on the same page. So if Sam and I are brothers and I own 90%, he owns 10%, and I want to, if option 2 were allowed, because he owns 10%, I would be able to transfer the permit to Sam. But if he owned 9% or 0%, even though we were brothers, that would not be allowed
Lineal descendant.
Yes,
prior
that's
to the
correct.
transfer.
If he was your
Lineal
lineal
descendant.
descendant, as we've defined it, but that's,
Oh, well, one of my
yeah,
other
yeah.
comments is about siblings. I'll get to that eventually. I'm wondering if the right solution here in my mind is actually some hybrid of these two things. Like, isn't the triggering event for something like this usually something that would typically involve a non-arm's length property transfer and therefore qualify for the RET exemption? And whatever the result of that, as long as it meets the familial structure that we agreed to, then you could transfer the permit to some other person. And I'm no expert in this, but I'm like wondering if someone in the family is, if a parent is doing, or two parents are doing some kind of estate planning and, put what something was in their name and it was owned in just the husband and wife's name, something was in their name, they're transferring it to a trust, and they're also sort of planning for the future and want to assign the permit to their child. Like, don't these things happen together more often than not?
I suppose they could. I would say that for option 1, where the permittee would remain the same, so if the parent put the property into a trust, they would, by the exemption that this council has already indicated approval for, by that death exemption, they would be able to pass the permit on at death in that scenario via their will or decree of distribution.
You'd have to wait till the death actually happens. I don't know what the implications of that from a tax or estate planning standpoint may or may not be. I have no idea, but that raises that question. And then I guess my last point is, like, should siblings be part of this or not? Is it only descendants? If perhaps neither sibling has any descendants and they want to pass something on to their sibling that they're very close with, should we extend it there? I wouldn't be opposed to that. I don't think that changes the intent here. But I don't really see these as, like, I understand why you're calling it less restrictive and more restrictive, and I appreciate you explaining it, but I also think that these things are so intertwined that it's probably some combination of the two. Like, you can transfer the permit, but only if there's a property transfer that's associated with it, perhaps? So, like, there's an element of option 2, but only if option 1 is satisfied?
So you want to limit it to include potentially both options, but limit option 2 only if a transfer has been approved pursuant to the first part. Does that make sense?
I think that's what I'm saying. I'm trying to think of a scenario where we would be okay with option 2 without option 1. But I think option 2 could be important when you're doing option 1.
Bill, I'm going to weigh in on this as well for a minute. I think this new element would be extremely complex. And I have a lot of questions that would take this meeting into a different territory. I want to know what are the full list of rent exemptions and who qualifies for those and why, and what is a rent exemption meaning here. And I'm keeping my eye on the RET funds to support affordable housing and how many exemptions we may be creating by default, which I'm not sure we are or we aren't. I think the other items in this ordinance have been fairly well vetted and are ready to move forward. I think that we could remove this item to go to a future work session and do a future code change when we fully grasp it, because I'm not willing to vote for something I don't fully understand the full implications of. I would want to see a couple of scenarios or a dozen scenarios created to say what happens with this family, what happens at that family, and what does it in effect do to the transferability. Because I start to see a link where you could have a chain where an STR permit passes on for multiple generations without ever paying a real estate transfer tax or with ever allowing the attrition for people who've been on the wait list to move forward. And so I really would need to see how the mechanics of this would work with the bigger program, which we're not really seeing, we're not really investigating. And I'm not saying it's wrong, I'm not saying it's not something I would support in the future at some form, but I don't think it's going to be settled and worked through language-wise tonight enough to include in this element. And, you know, it's always my impression from things that, you know, on first reading, it's supposed to be pretty much the scope of something, and you can narrow it down by second reading, but I don't like expanding it wildly at second reading without that full review. And we, you know, of all the entities that have already looked at the first elements, and then now we're just adding this in. But we haven't heard from P&Z or HBC on this, and we haven't heard public comment on this element. So I'm going to say I don't think we should continue this into this meeting, into this code now, that we should commit to take it up again. And I'd like to have some tax attorneys here. I'd like to have some third-party advice on this that is separate from this, but again, to the implication of the integrity of the STR program. So does that make sense to?
Yeah, and I appreciate that and understand it. I also know how much work it takes to open these codes and work on these codes and then close this stuff out, and how many steps are involved in that and the bureaucracy that's related to it. So my suggestion would be, you know, and maybe someone from the public would disagree with me here if they want to, feel free to say that tonight, but maybe we continue this. And I don't know that any of although I agree with all of the changes proposed in Ordinance 8, I don't know that any of them are more time sensitive than this or vice versa. And perhaps we could keep the code book open, so to speak, get the information that you're looking for, have that conversation and that work session without closing this and then reopening it again. That'd be my only.
Yeah, the only thing I would feel about that is that permit renewal is right now. And so if people want to take advantage of the other improvements that we're making in the program, it has to go forward now. I also don't know that the time frame between now and a week from now, 2 weeks from now, Tuesday, would be enough to really satisfy the questions that I'm asking. I mean, I want to know, why was a 10% threshold picked? Why wasn't it 15%? Why wasn't it 25%? You know, I have other questions that I would ask about this before I would really feel like it's cooked. And so new numbers on the wait list, new numbers on what we're seeing on attrition, you know, how this potentially could change that. Would it be a 10% change to our attrition rate? Could it be 20%? I just don't know. And you did bring it up at first reading. They've responded well at first reading, but to me, it's uncooked. And I'm just saying, I will not vote to pass this if we're now including a transferability element based on a 10% threshold that I have no idea where it was derived from. or how it will affect our program overall. I'm not going to take that flyer. But that's
Ben,
just
is
me.
there a way to pass Ordinance 8 and sort of still keep the book open, so to speak?
Yeah, I think so. As council knows, when we do a code amendment process, the first step is a policy resolution, and then the ordinance process proceeds after that. I don't think that there's anything that precludes an ordinance from passing that responds to that policy resolution that could remain open to allow for additional, more targeted changes to the code. Still require an ordinance to do so, but I don't think that we would have to go back to square one with a new policy resolution. And I will just say, to acknowledge, I think the complexity that the city attorney's office and our staff sort of worked through on this is why we did a continuation. And I think there's a Venn diagram with Rhett that's here. Some of these things in terms of permit transfers, I think we can handle divorce and death without bringing in finance and having a sort of a red exemption conversation with our finance department. I do think that both option one certainly requires a red exemption to be complete when the property is transacting, allowing that permittee to remain the same. But I do think it raises complexities. We've thought it has raised complexities, understanding the complexities of estate planning and tax consequences and why people would be engaged in this has been difficult for staff to navigate and land on something that maintained the integrity while giving the additional flexibility to families as they're working through these issues. So we're open to further analysis of this, but it has been a topic of complexity, I think, for us to try to land on. I think this was both of these options, I think, were efforts to try to get to that point. I think there's still questions within, but to answer the mayor's question, that 10% ownership stake is what we require in a LLC or in a family trust for a person to be identified as the actual permit holder. The real life person that has to be the permit holder has to have at least that share of ownership within that ownership entity. That's where that number came from.
Yeah, I would like to find a path to have a really thorough discussion about this. I'm real nervous about the city in the future having to have our own tax attorneys in-house to investigate LLCs, to find out do we still have 10% ownership, or has it been further diluted, or is this, or is that? I just see us suddenly becoming immensely entangled in estate processes and estate lawsuits later on, and I do not want us to be there. So if the rest of council has questions on this item or other portions of the STR code as we've seen go forward, now would be the time, and then we will open the public comment. Okay. Well,
I like Bill's idea of passing as much of this as we can tonight and keeping the book open, if possible.
in a way that we can do, that's what I'm kind of saying, it's not, and if the work session ends up, it closes the book, but we at least get some real scenario building, some sense of the depth of complexity that we feel we'd be signing our staff up for in the future, and all the other components. I mean, I start to say, what if you don't have any kids at all, but you have a favorite cousin? Why not them? How far does it go? How far does the transferability go? I had one friend who received a house up Castle Creek that was worth a fortune, it still is, and he got it for like $65,000 because the people just liked him, and he'd been a house sitter for him for years. At what point is that the person? He's lived in this house for 20 years as my housekeeper.
How do I apply for that job?
Yeah, I know. That's what I'm saying. I'm just wondering, how far do we end up going to eviscerate the program?
Maybe in that work session, Pete can talk to sort of rent exemption administration, which I know he's deeply experienced with.
I'd love to know more about that side too. Sam?
Yeah, definitely want to hear from the public about the rest of this, and then also I just would want to know what other communities do in this situation. I can't imagine we're the first.
Yeah, that would be a good question to answer too. Thank you. All right, we will now move on to the public hearing on this code. If you will identify yourself for the records, give us about 3 minutes of your time and your opinions, and who wants to be first? I'm opening the public comments.
Get somebody online.
Okay, we have, B is online again. Brian. We are unmuting you now, and then we'd love to hear your comments. Thank you, Brian. I think you're there you go.
Okay, I have no problem with most of the changes to your problem. I would think that if you're looking at the transferring, I own 2 properties that are both condos and both in the short-term rental zone, lodging zone, and I can tell you that you are wading into a quagmire of problems when you start changing your current codes, but that's my only comment on that. On the other issue that I'm vehemently opposed to is eliminating the annual affidavit. And I understand that the city is concerned about maintaining HOA rules, or that you're not wanting to enforce HOA rules. I'm not talking about HOA rules. I'm talking about short-term rental rules. There's a long list of things that after people have been renting for 2 or 3 years, they forget that, oh yeah, maybe I should have a functioning fire alarm in there. And by allowing the HOAs to monitor that for you, basically gives them the ability, or gives the HOA the ability to police something that you cannot, there's no way the city can police on its own. So I would tell you that you should keep this, and I understand that the city, people, Emmy and company find this onerous, and I can understand too that a lot of HOA managers find this onerous, but quite frankly, from the HOA owner or manager situation, this is something that they could easily monetize, and I don't think anybody is. I also think that it gives them another tool in their kit to monitor how these properties are rented and to whom they're rented, which I think behooves us all to be concerned about. I've put together emails to every one of the council members as well as the STR staff with my other reasons for this, and they're not necessarily just managing HOA rules, but I think that's more about managing the short-term rental rules. So that's all I've got.
Great, thank you very much. I appreciate that. We also have Diane Spicer who would like to make a comment, if we will unmute her. Diane, you are unmuted if you'd like to speak.
Hi, thank you for letting me comment. I'm an HOA manager here in town. I own a company called Aspen Places. I manage about 12 different HOAs, condos in the core, and I am the one that usually signs a lot of those forms in the past. And I, along with one of my associations, I'm not sure if you're all aware, but the Colorado Common Interest Ownership Act has made it virtually impossible to enforce any rules on HOAs at this point. They have a 30-day or a 60-day cure period, and from an HOA standpoint, by then the short-term renter is gone. For example, I often run into situations where short-term rentals don't follow rules and they leave their trash outside, which a bear gets in. Then Laura, the bear lady, comes around and is yelling at me, the HOA manager, because this person this person left their trash outside, as an example. So we have short-term renters in a complex, right? And then we have the people that really don't like short-term renters. The HOA acknowledgement form, if it has to be signed by the HOA manager, really allows us to monitor our own people also into following those rules. So if I continually have a unit that's short-term renting that rental agent or that owner doesn't really care, and they're leaving their trash outside or violating other city rules, parking in the wrong spot or whatnot, then I can have a little bit of teeth to try and get them to comply with the rules, not only the HOA rules, but the city rules for their short-term renters. I mean, we all know we have bad rental agents in town and we have great rental agents in town. I work with them all. And so having a place for the HOA to sign off on that affidavit to me is crucial in allowing me to be able, so then if I have an owner who continually violates the rules, I can, 4 strikes and you're out. We're not signing your permit next year because you continue to be disruptive to the community and the city. We have had an attorney vet a form that basically is able to circumvent the Kiowa law because enforcement's impossible. We don't charge fines. We simply just tell them, we're not going to sign your permit next year if you have this many violations. If you have barking dogs or you bring a dog and you're not allowed. So it's not really to enforce not that we allow short-term rentals or we don't. It's really for us to help you enforce rules around the city and also our own HOA rules so that everybody's happy. The short-term rental people are happy, and then the people that really don't like the short-term renters feel like their HOA has some stake in the game.
Thank you for that, Diane. I appreciate your comments. Let me ask, Diane, have you ever reported a violation to the city of STR permittee in one of your complexes? Because that's where the enforcement would really happen, that the 3 strikes you're out, that you've had multiple violations on your STR permit, we would pull the STR permit.
I don't find that report, yes, I have tried, and I don't find it simple or that the city really does anything about it, to be honest with you. And I love, like, the 311 app is my new favorite thing on the planet. So that's super easy to send things in there. I've spoken with short-term rental people about, enforcement, and it just doesn't really go anywhere.
Okay, thank you for that. We appreciate that. Are there additional public comments on this matter? Sir, please come forward and someone give him a seat and just identify yourself for the public record, please.
Yep. Ben Wolf, I work with VIIIA Properties. Just want to clarify a couple comments I've heard. The first gentleman brought up smoke alarms and safety elements, and I want to make sure everyone's aware that that's a totally separate affidavit, and that affidavit is not going anywhere. So everyone's required to submit a self-inspection affidavit, which is separate from the HOA compliance affidavit. And that is basically, stating that you are following the safety protocols on an annual basis. At VIIIA, we're inspecting every unit annually, confirming that everything's in place, and then signing the affidavit. So that is not part of the HOA compliance affidavit. I totally feel where Diane's coming from. VIIIA manages over 55 HOAs, so we're pretty well versed in HOA management and obviously the impacts of STRs. I honestly do not see a lot of issues around STRs, and I don't think that the teeth of enforcement come from an HOA compliance affidavit. And I personally would not feel comfortable withholding the signature on an HOA compliance affidavit because somebody may or may not be violating rules, unless it's in the governing documents that an HOA does not allow STRs. I personally would not sign something that says they're not allowed. And I agree with her, it's difficult to enforce HOA rules and there's a process. But if you follow that process, it is possible. And personally, I just think the staff has added a sign-off that's going to make it more efficient for people to acknowledge that they're in compliance with their HOA. And if there's violations beyond that, it's up to the HOA to enforce them. So just wanted to clarify a couple things.
Thank you for coming to the table.
Thank you all.
Appreciate your comments. We'll make one more final call. Are there others here to comment on the STR codes?
Mayor, I just wanted to note, Jonathan Fieldberg sent Feinberg sent an email to council at 4:25 PM this afternoon. So I just wanted to make sure you'd all received that and read it. If not, I'm happy to read it into the record.
I have not read it, so let's read it into the record. At 4:25, it's getting a little late to catch us.
Yeah. and-
But let's read it into the record and make sure the public record is solid.
I can, yes. This is, dear city council members, I represent quite a few well-tenured Aspen clients who are fine stewards of Aspen's short-term rental matrices. One set of these clients is currently doing some estate planning and putting their property in a trust for their family consisting of 2 parents and their 3 kids. This happens frequently, as you likely know. In any event, per the current interpretation of the City of Aspen Land Use Code, specifically Section 26.530.030, subsection A, subsection 5, they were told they would lose their permit with any change of structure to their ownership entity despite the property staying completely within their 5-member family. The signer for their proposed new trust is the owner and/or previous signer for the property. In other words, the property isn't in any way being conveyed to someone new. It's the same owners under a different ownership entity. On behalf of many concerned and compliant Aspen property owners, I humbly request that our esteemed council reconsider how Section 26.530.030, subsection A, subsection 5 is interpreted. Respectfully, Jonathan Feinberg.
Great. Thank you very much for that, and I think that that is an item that we will be looking at in the future. So, okay, with any other public comments? I will close the public comment section of the meeting, bring it back to the council table, and let's see, ask, would anyone have a motion on ordinance number, where are we? A public hearing down here. Ordinance number 8, series of 2025. I would like to see if there's a motion to approve on second reading.
A question first.
Oh, yeah, please.
Just hate mucking it up, but the HOA affidavit, was that more for our benefit or for the HOA's benefit? It was a bureaucratic thing for us that it was tough to deal with as far as doing the annual HOA affidavit, or?
Are you asking?
Eliminating it?
Yeah, but what the purpose of eliminating it for the city, what benefit does that do for us?
Really, we proposed eliminating this, the need for the affidavit in response to our customers' requests. So the purpose really was to streamline the application requirements at renewals.
As I recall from one of our work sessions, it was that a lot of times HOA boards only meet once a year, and getting a signature on each individual permit became problematic for getting the boards together to do them. As opposed to, it's not the burden on us, it was more the burden on the users of the system.
Yeah. Well, once again, not trying to muck it up, just wondering if there should be some level of opt-in for that for certain HOAs that want that versus the ones that don't, just because we've heard that some want it and some don't. And it seems to be not much to us at the city, but I do feel, I guess, badly about taking away something that they have used as a tool to make their lives better in their HOAs.
Agree.
Yeah.
And totally acknowledge that. I would defer to legal on kind of the legality of letting some opt in and others not.
Ben, if you want to make a comment on that.
I'll let Kate
Yeah,
go first.
Well, I think from our perspective, this is a relationship between the city and the applicant, not the HOAs. And handing this to a third-party HOA to opt in or opt out and require, it seems to me to be including a third party in our application process. Realistically, when we do anything, building, zoning, land use, there is no legal requirement that the person provide proof of HOA approval. That is something that this city has done to recognize and strike a balance between trying to make people aware of HOA requirements and using this process to kind of serve as a check for those individuals to know they have to reach out to their HOA first. Realistically, though, in my opinion, well, first of all, my office has consistently opined that we cannot enforce HOA regulations. And as Ms. Byrne pointed out, in those situations, we'd be sort of giving power to a third party that's outside of this relationship between the applicant and the city, if that makes sense.
Thinking about it, Kate, and what you're just saying, if an owner of a unit in a multiplex condo was going to come into the city and get a building permit to totally remodel their kitchen, and rip things out, put new things in, we wouldn't require an HOA approval to issue that building permit.
You have in your building codes and your land use codes, in the application process, we ask for a very similar affidavit in all those scenarios. What we do not do, however, is generally, we often, our opinion is that we cannot enforce HOA rules. So to the extent that there's a factual dispute as to whether or not an HOA approval was properly sought, we have very little power to sort of, as Ms. Byrne pointed out, judge who's right and who's wrong in that situation. We don't have access to these documents. We don't have access to the bylaws. We have no control over them. And really, in the courts, we don't have any standing to regulate these types of things.
That's fine. I just want to know, is there a legal liability to the city to have like an opt-in for this, since it's kind of?
I think there is.
There is.
Because I think
So-
at that point, you're treating different people differently based upon a third party, not your decision. Does that make sense?
Yeah, I just want that clarity, because there is obviously always an unfortunate nature to making a change where you're trying to make things better, and it didn't necessarily go that way for certain HOAs.
I would add, I support everything that Kate just said and aligns with my thinking on this, but I would also say, one of the other difficulties that staff has is understanding who the HOA is and who gets to speak on behalf of the HOA. The leadership of HOAs are constantly changing. They're often very political processes. And I think the city being in a position where we're coming to an understanding of who's speaking on behalf of the HOA and what HOAs exist and which HOAs don't exist and which HOAs are legitimate, and it would become a very difficult circumstance for us to engage in, of trying to discern, make sure that we've got all HOAs captured, and then who is speaking on behalf of an HOA from one year to the next would be a very difficult thing for us to navigate.
Then one last comment, just to close this out, is sympathy to Diane and Brian, and hoping that our staff can reach out to them to show them all the tools about how to enforce bad behavior and actually enforce it, because, SDRs are so controversial in this community, and it's always tough to hear when people are detrimented by them, not just from the loss of locals potentially, but more from the disturbance that it causes. And that's not something that I think anyone on this council really wants to tolerate within our regulations.
I agree. And, it's a tough thing when you're living in a combo complex. I have renters above me in Hunter Creek. It was a deed-restricted building, but this is a remaining free market unit. And sometimes they get pretty noisy late night after coming home from work, and we're having to work early in the morning. And you get a little hesitant about, do you really want to call and put in noise complaint? Because it's going to be, once two or three have happened, a $300 fine or something like that. But at the same point, we need our sleep. And, so we go up and knock on the door and ask quietly. But you don't want to do that with strangers. You don't even know who these people are. You hear about road rage and people shooting each other over nothing anymore, and especially at 2 a.m. in the morning when wild things have already happened. So I can understand, but it is a matter whether it's making your capital repairs and having a good capital savings account, or following, does your HOA allow these, and how does it enforce, and how does it enforce on violations? And it's important for the HOA to take that responsibility on, as opposed to try to put it onto the city itself and managing violations. So I agree with you, and those are good comments. And I'll come back again to saying, is there a motion to approve Ordinance 8? And we can have further discussion after a motion's on the table if there's other comments.
So moved.
Okay, on ordinance, and it's been moved and seconded. Do we have further comments from the table or questions?
I have a more broad comment, and that's just that in my short time at the council table, STR permits are the one topic I've probably received the most feedback on, and it's from both camps. It's those in favor and those that are against. And so to me, that says that I think we've struck a balance somewhere in the middle that's working right now. It's not perfect, and thanks to the council, thanks to staff for being willing to tweak it, and there's more to come. So it's a dynamic process.
Very good. Any other, Bill?
Yeah, thanks. Again, I appreciate the sort of evolution that staff has brought forth here in response to community feedback and user feedback on this. I think they're good changes. I look forward to discussing further the transferability provisions. I do think that those are important and fair. And just wanted to express, I understand everyone's position on this, but express my disappointment that we haven't figured out a way to sort of adapt to some of the other inequities that seem to be there in this program, like certain buildings that are precluded from certain zone districts because of their underlying zoning, but not necessarily the original intent of their development or their neighbors. And I'm hopeful that at some point in the future we can figure that out and evolve the program to adapt to those sort of inequities and without undermining the program, without upsetting the broader community. But I do think that there's a few holes in the donut, if you will, that need to be addressed. Thanks.
Thank you. John?
Yeah, I also want to acknowledge the time and effort that staff has spent on this, addressing these unanticipated issues that have arisen during a relatively new program. When I look at other communities, Breckenridge and Keystone come to mind right off the bat, and how many STRs they have compared to their population. I just want to thank staff for helping us take this issue by the horns, and I see this as a major success. Thanks.
Yeah. I agree with those comments. As the saying goes, you can't put the toothpaste back in the tube. And we've kind of stopped it before it went all out. And a lot of other communities are only now just trying to get a grip on this and what it's doing to their community base, their worker force, all the issues, neighbor concerns, residential neighborhood integrity. So I think things like the HOA requirement were put in at first because we wanted belts, suspenders, and seat belts, and try to take that easy. And we're learning as we go and being able to improve the program for usability of the people who are using it. I do support the caps and I support the limits overall. We have an awful lot of new hotel beds coming online anytime soon, and the last thing I think we need to do is lose more of our either longer-term rentals, over 30-day rentals, or places where people still live. And it's surprising to hear, as you said, there's the both sides of the STR question with people who find their property taxes going up because the home near them was bought by an LLC based on the potential rental income, and the person who is just there to be a resident is now paying the higher property taxes. So it has boomerang effects across the community in multiple ways, and we're dealing with the changes as they come up. So we have a motion and a second on the table. Nicole, will you call the roll, please?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you, and thank you for your very dedicated and research and hard work sorting all this out. And we'll be seeing you again, I guess.
Yes.
We will now move to ordinance number 10, series of 2025, the City of Aspen 2025 Budget Fall Supplemental. And this is a document detailing items that we had asked to be spent or that needed to be spent as unanticipated things came up. This is not the 2026 budget. This is just memorializing commitments and expenditures we've already made this year. Thank you, Matt.
Thank you, Mayor. I will just point out, I mentioned it at first reading, but the one change from first to second reading was to remove the $100,000 new request from Kids First.
Okay, thank you. Does any council members have questions on this from first reading? No. I will open the public hearing. Is there anyone from the public here to speak to ordinance number 10, series of 2025, the City of Aspen 2025 Budget Fall Supplemental? There being none, I will close the public hearing and bring it back to the table for a motion.
I'll make a motion to approve ordinance 10, series of 2025, City of Aspen 2025 Budget Fall Supplemental.
Is there a second?
Second.
We'll give it to Bill. He's a little louder. You have to be a little louder. Okay. Just joking. Will you call the roll, please, Nicole?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you. We will now move on to ordinance number 11, series of 2025, the City of Aspen 2026 fee ordinance.
It's also mine.
Okay?
Just a reminder for the public and for council, fees are reviewed annually both by staff and council as part of budget development, with recommended adjustments accumulated and adopted through an annual ordinance. Proposed fee changes were presented and discussed during the October council work sessions, as well as published in the 2026 proposed budget book. These fee changes are built into our 26 revenue budgets, though actual collections will depend on volume of sales or services rendered. Staff is recommending approval of the proposed 2026 fee ordinance on second reading.
Okay. Thank you very much. And I think there was additional work done since our first reading to talk to the Golf Advisory Committee, and the letter supporting the proposed changes is in the packet now. Is that correct?
Correct.
Correct. I had a few further questions. I emailed in to Pete today, which he forwarded on to Jim. Thank you very much. Satisfactory answers about how we are deciding who is qualified for a pass, and that the significant changes being made for this coming golf season should alleviate some of the issues on getting a tee time and create a fairness with the local rate that people can purchase a game of golf when they're not getting some of the previous passes that were offered before. Sam?
I just wanted to ask, because I didn't ask earlier, about whether that other alternative proposal that P had emailed us last week was brought up to the Golf Advisory Board, and if they just outright rejected it or said, leaned one way and said maybe. And then also, depending on his answer and how this goes, just wanted to say, the Golf Advisory Board, you, everyone at the city regarding this does their absolute best, and I know you've done your due diligence and that, you know, you put everything in to make sure it goes well next summer, but if it actually ends up not being as great as you expected it to be, we'll be here again next fall to potentially change it for the following summer, because I know there were definitely some passions about this, and it doesn't sound like everyone's going to get their way.
Yeah, Jim Pratt, manager of the golf operations. We did meet, some of the board members are here. They're happy to answer some questions as well. But yeah, we had a meeting. They were unanimous in their decision that the originally proposed structure is the recommendation from their standpoint. Staff is in agreement with that. Like you said, you can never make everybody happy, but the changes that were made or the adjustments that were made are what we feel is best to address the biggest issue for 2025 was tee time availability. So that was certainly addressed in the new structure.
I mean, my second comment, I'll leave it at that as far as just like understanding the qualms that come with this, and that there's not everyone's going to be happy in that, you know, eliminating passes and the price structure definitely hits me as a non-golfer. Just looking at it being like that seems tough pill to swallow, but also sitting up here relatively ignorant to the situation in the sense that I don't golf and I'm not over there. I have to go with the trust of the Golf Advisory Board, who I do trust, in yourself. But also, like I said earlier, next, after this summer, if things are not going as anticipated, we'll be back here talking about the following summer to maybe make some changes again.
I certainly acknowledge your concerns and understand where you're coming from.
Thank you. Appreciate that.
Very good. Other comments or questions?
Here.
Okay. Then I would ask, is there a motion to approve ordinance number 11, series of 2025, the City of Aspen 2026 fee ordinance.
We need public hearing first?
Oh, sorry.
I messed you up
He,
on that.
no, thank you, Bill.
Sure.
Appreciate that.
I only say this because I don't want to do this twice.
Yeah, and I am not perfect, and I love people who help me out. So we're going to open the public hearing on ordinance number 11, series of 2025, City of Aspen 2026 fee ordinance. Is there anyone online? No, I'm not seeing anyone. Is there anyone in the room who would care to comment on this item? There being none, I will close the public comment and accept a motion, please.
I'll make a motion to pass ordinance number 11, series of 2025.
And a second.
Second.
Very,
Love it.
very good. Nicole, will you call the roll, please?
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Yes, thank you very much. We will now come to ordinance 13, series of 2025, changes to Title 25. And thank you to all the members of the Golf Advisory Committee who came to a special meeting, who sat in and think about these problems all year long. We really appreciate it.
Good evening, Mayor Richards and council members. Ryan Laybach, Deputy Utilities Director. I have with me Cole Langford, Utilities Business Service Manager. We are here for the second reading and public hearing of ordinance number 13, series of 2025, which contains the Utility Department's annual updates to utility rates and fees captured within Title 25 of the municipal code. This material was reviewed with City Council at the October budget work sessions and last week's first reading. Overall, the language, rates, and fees of Title 25 support the water and electric utility daily and ongoing functions for the community. These rates and fees are critical to ensuring daily operations as well as long-term resiliency of our water and electric departments. Staff seeks council approval for ordinance number 13 here tonight.
Great. Thank you. This is our last ordinance on our regular agenda. We have no action items, and then we'll be going into executive session. So I will start by opening the public hearing on this item. You've all heard the description. It is the utility rates for water and electric, which finance the rebuilding plan for both of those two city utilities. Is there anyone here from the public to speak to ordinance number 13, series of 2025? There is no one online and no one in the public to speak to this item. We will bring it back to the council table for motion and then discussion on the motion. Is there a motion to approve ordinance number 13?
So moved.
Is there a second?
Seconded.
Okay, discussion. Bill?
I'll reiterate what I said the first time. I'm fine with the rate adjustments. I do think that the fee adjustments are larger than necessary. I don't feel that they're well justified. I can't support this with those magnitude fee adjustments for both water and electric.
Okay. I understand your concerns, Bill. I wish I wasn't having to vote for a fee increase on either of those items, and that it's fair to say everyone at this council table as council members will be paying those increased fees as well. It's not as if we're exempted. And that, for me, it is simply the long-term health of those two facilities, being able to really live up to the increased and tariffed increased costs that are being passed along to us, the costs that are being passed along to us for purchase power and for using the XL transmission lines. And, you know, when someone is getting their tap fees to get into the system, they're benefiting from hundreds of millions of dollars of investments that all of our community has already made to have this 80-mile-long system in place. And so I would be the last one to reduce tap fees for buying into our system when there's a redevelopment on homes. But that's just my opinion on that. John?
Yeah, I'd like to point out that one of this council's goals was resilience for the city of Aspen, and this addresses exactly that, and that's why I support this 100%.
Thank you. Other council member comments? Bill, please.
Just want to speak further to it. Again, I'm supportive of the infrastructure upgrades. I understand how rates are moving up partially as a result of those infrastructure upgrades, and I'm supportive of that. What I'm not supportive of, which doesn't make sense to me, is the fee increases that are proposed and the magnitude of those fee increases. Tap fees, and they call it, with water, tap fees; with the electric, they call it community investment fees, but they're essentially the same thing. And part of the reason why I'm opposed to it is because if you want to electrify your home, something that we talk about here, or add further electrification to your home, you're going to be hit by those increased fees, even though you're trying to meet what may be your personal goals or the community goals, or both. And I think that if our goal is to have enhanced rates of electrification in our community, this is a deterrent to that. So I encourage you all to think carefully about that, because it's actually a deterrent to what seems to be the goal of many of you here.
Thank you, Bill. I can appreciate that. And it just reminds me of something that we had discussed at one of the other work sessions on this. I just wanted to follow up on it as a comment. It's not to change this ordinance or this process, but we talked about the difficulty when a new transformer has to be put in because there's a redevelopment, it's a more expensive, need a bigger transformer. And working with staff to figure out, is there a way that when others in the future want to tap into that transformer, they have a pro rata share of its cost? So that was an issue I think you raised, and was a good one, and we are looking through staff as a way to address that in a more equitable manner. But that is that. If there are any other comments on this item, we do have a motion and a second. Then I will ask Nicole to call the roll.
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
No.
Counselor Rose?
Yes.
Mayor Richards?
Yes. Thank you very much. And I think we have no action items. We're going to go into executive session. Our attorney will explain the reasons why. We will not be returning to this room to end the meeting so that grassroots can go ahead and pack up. We do not, we will, you know, no, I was going to say, we are able to give direction but not make decisions at a executive session, and we will be conducting that down in the council meeting room.
Thank you, Mayor. Pursuant to Colorado Revised Statute, Section 24-6-402, subsection 4, subsection A, an executive session is requested for reasons of discussing the purchase, acquisition, sale, lease, transfer, sale of any real, personal, or other property interests, subsection 4, subsection B, conferences with an attorney for the local public body for purposes of receiving legal advice on specific legal questions, subsection 4, subsection E, determining positions relative to matters that may be subject to negotiations, developing strategy for negotiations, and instructing negotiators. The specific items of discussion involve the following: the lease of real property interests, direction to negotiators, and discussion with the city attorney regarding the lease of property at 455 Rio Grande Place, Aspen, Colorado. As the mayor noted, we will convene both the regular meeting. We will not re-adjourn in this particular chambers. We will adjourn from the Electric Pass conference room, and the city clerk will maintain a recording for not less than 90 days. So that is the request before you. Thank you.
Is there a motion to go into executive session based on the citations of our attorney?
So moved.
Seconded.
All right, it's been moved and seconded. Nicole, call the roll, please.
Counselor Benedetti?
Yes.
Counselor Doyle?
Yes.
Counselor Guth?
Yes.
Counselor Rose?
Yes.
Mayor Richards?
Thank you. And thank you, Grassroots TV, and thank you to our viewing audience.